Distinguished guests, ladies and gentlemen, they're still located at the foyer. We would like to kindly invite you to join us in the Istana Ballroom. You're able to bring the tea and coffee and also the little bit snack. You're able to enjoy as long we're going to start the sessions of the second day. For all committee, please kindly assist if we still have delegations or participants that's still located at the foyer to enter and join all of us inside the Istana Ballroom. All right. Good morning, ladies and gentlemen. Assalamualaikum warahmatullahi wabarakatuh. Welcome back with me, Melati Dewi, your MC for the Asia Pacific Justice Forum, Building Partnership for the Rule of Law. I hope everyone still feels fresh. We're going to proceed. The second day of the forum highlighting the topic, finding solutions, working together. Are you ready? I'm not hearing anything. Ladies and gentlemen, are you ready? Yay! What about wonderful spirit? Okay, let's proceed. This morning, we already finished the workshop that led by Alejandro Ponce, highlighting the workshop on new frameworks for advancing access to justice, thinking forward together. And now we're going to have interactive sessions that's also divided into two parts. This is highlighting on smart regulations for a healthy information ecosystems. The first part of the session will be best practices and innovation presentations. The second part will be interactive discussions. Without further delay, I would like to invite kindly our lead moderator, Mr. John Neri, Rappler, the Philippines. John Neri, please lead the sessions. Give the warmest applause, ladies and gentlemen. Thank you.
Thank you, Melati. Good morning. Again, my name is John Neri. I'm a journalist from the Philippines. I work with Rappler, and I also have the privilege of serving on the board of the World Justice Project. And my happy task today is to moderate a very important session. The subject is life or death for my profession, my industry. But it's not just media that's at risk. Disinformation divides society, it incites violence, it promotes harm, and it subverts the rule of law. In fact, the very possibility of the rule of law. There have been some government-led interventions against disinformation, but unfortunately, whether by accident or by design, these interventions end up silencing the media, or civil society organizations, or critics of a government in power. So what we'd like to do today is to ask ourselves two basic questions. Number one, how can we best understand the scope and the scale of the problem? I think you will agree with me that in the last 6 or maybe 7 years, the challenge of disinformation has reached crisis proportions. We're looking at a crisis in disinformation. How do we best understand that, especially in the Asia-Pacific context? Much of the literature, unfortunately, is still written in North America or in Europe. And the second thing we'd like to do with this session is to ask ourselves, how do we meet these challenges? What can we do, either by ourselves or working together, to help build or maintain a healthy information ecosystem? I think of our session as consisting of 3 parts. The first half hour or so, we will hear from presenters, 3 presenters, on best practices, how to push back against disinformation. And then, for about 45 minutes after that, in the second part, we will have a panel of experts who will go into the weeds and discuss exactly what the problems are with disinformation in our part of the world. And then the third part, we'll have maybe half an hour to field questions from the floor, both physically and online. So those three things. Now we'd like to start on a high note. Let's talk about best practices. The first speaker I would like to, incidentally, we've invited the experts, and there are many reasons for inviting them. I don't have the time, and neither do you, for us to read everything in their bios. You can just scan the QR codes at the back of our program to better appreciate exactly where our experts are coming from. Our first expert is coming from South Korea. You heard him yesterday. He asked a very interesting question in the open forum in the afternoon. Let me call on Dr. Ethan Hee-seok Shin, legal analyst with the Transitional Justice Working Group in South Korea. Dr. Ethan.
Did you get the PowerPoint slides up? Okay. Right, thank you very much. In late August 2021, last year, the South Korean National Assembly was on the verge of passing an amendment to the Press Arbitration Act, which, among other things, would have allowed punitive damages in civil lawsuits for quote-unquote fake news, and also shift the burden of proof by requiring the journalists who are sued to prove that they have done nothing wrong. So how did this bill, this extraordinary bill, came about in the first place? Not by the conservatives, actually, but by the so-called self-professed progressives in power at the time. Next slide, please. So let's rewind the clock 2 years. In August 2019, then South Korean President Moon Jae-in, a former human rights lawyer himself, appointed his top aide, Cho Guk, as the new Minister of Justice. Now, unfortunately, almost immediately after this appointment, all the various scandals involving Cho Guk and his wife Jung Kyung-shim hit the news headlines, and the state prosecutors opened investigations. And as a result, only a month after Cho Guk's appointment as Justice Minister, he was forced to resign in disgrace. If the things had ended there, it would have been just another boring political scandal, everyday event in South Korea. But Cho Guk was not just any ordinary politician. He was actually President Moon's protege, and he was widely expected to run in the upcoming presidential election as the main contender from the ruling party. So when this incident happened, the ruling party politicians and supporters blamed the media and also the state prosecutors for basically conspiring to undermine their favorite politician. Could you move to the next slide, please? After the landslide victory by the ruling party in April of 2020, the politicians from the party moved to basically clamp down on what they viewed as the conservative and hostile media in South Korea. And one of the plans that they basically hatched was to revise the Press Arbitration Act to introduce punitive damages, like I said, for the fabricated or factually incorrect news, and and also to require the accused journalists to actually prove that they are innocent. And although this kind of punitive damages is very common in the U.S., it's not really popular in any of the jurisdictions, as you know. And even though South Korea has, since 2011, began to adopt this kind of punitive damage laws in piecemeal fashion, oh, sorry, could you, next slide, please? Yeah, so these Oh, these basically are the explanations of the punitive damages laws in South Korea. And as you can see, these laws were mostly targeted at addressing the unfair business and labor practices that weren't really being addressed in the court at the time. The Press Arbitration Act obviously was a very totally different effort. And there was widespread fear that obviously this would result in the undermining of the press freedom in South Korea. And to my knowledge, there's no other legislation in anywhere around the world that actually singles out journalists for punitive damages. Next slide, please. Unfortunately, at the time, basically with the majority that the ruling party had in the National Assembly, all that was standing between its enactment was the final vote before the full National Assembly and the president's signature. And this is when I turned to the UN Special Rapporteur on Freedom of Expression, Ms. Irene Khan. So as you have heard from Professor Satterthwaite and Ms. Ankana yesterday, the UN Special Rapporteurs and other human rights experts are appointed by the UN Human Rights Council on various country and thematic issues, including the freedom of expression, the human rights defenders, enforced disappearances, and the independence of the judiciary. So I previously had experience working with the various special rapporteurs because I work for an NGO that documents human rights violations in North Korea and other countries. And this time I was, for the first time, putting my skill set and applying that to the South Korean situation. Next slide, please. So I emailed Ms. Khan explaining how the press freedom in South Korea is threatened by this new bill, and I asked her to basically write to the President Moon Jae-in, to veto the bill because I expected her to respond at best about a week after I wrote to her. Which would have been after the bill's final passage in the National Assembly. To my surprise, she actually responded, sent a reply to the South Korean government 2 days after I first emailed her. And not only that, she actually made a very interesting request that the South Korean government actually share her letter with the members of the National Assembly before the final vote takes place. Now, this had a very immediate effect, the immediate impact in the National Assembly, and the ruling party decided to postpone the vote for 1 month and to create the quote-unquote consultative body with the main opposition party to deliberate on this issue in this 1 month period. And to my personal excitement, I was actually asked by the opposition party to become a member of this 8-member consultative body, largely thanks to because of my work in writing that first email to Ms. Khan. Next slide, please. So yeah, that's how the events happened in a very quick succession. But this did not mean the end of the bill, because basically the progressive party in power at the time was trying to buy time. After a month, they expected this kind of public uproar to kind of die down, and the public would lose attention, and then they can finally put the bill to a vote and have it done with. And they even offered some cosmetic changes to the bill that weren't really a solution at all, but they sold it as such. And it also appeared to be having the intended effect in swaying the public opinion. Next slide, please. So things looked very grim until Special Rapporteur Khan made another very timely and very critical intervention. So just days before this 1 month period was supposed to end, she actually held a Zoom press conference with the South Korean journalist, where she not only again repeated her criticism of the bill, But she also pointed out the cosmetic changes that the ruling party suggested were not really solutions at all. And not surprisingly, the South Korean press very extensively covered her press conference. And again, this helped to turn the public tide again against the impending bill. Next slide, please. So basically, we were holding breath after this press conference, how the ruling party would react. And initially, there were actually some hardline supporters of the bill who still pushed for this bill to be put to a final vote. But even within the ruling party, many were starting to have doubts, becoming more hesitant about the bill because of the international and domestic criticism that they were facing. And basically, the president's office wanted to kind of a nice way to exit from this all this situation. And the way they did that was by agreeing with the main opposition party to delay the vote for another 3 months and create another special committee to look into the matter. And that effectively killed the bill. So that's when we all had this collective sigh of relief. Next slide, please. So, as you know, the United Nations is often called the world's greatest talking parlor. But as this episode illustrates, it can be a very effective talking parlor when there is this kind of decisive international action combined with a receptive domestic audience. And I was very grateful to the Special Rapporteur, not only for her timely intervention, but she was very clever in asking, for example, the South Korean government to share the letter with the lawmakers because it incentivized President Moon to actually delay the bill's vote so as to avoid he himself being put in this very awkward position of having to either sign or veto the bill, which would have basically made somebody upset. And it was also very critical that South Korean journalists, regardless of their political opinions, were pretty much in unison against this bill because nobody wanted to be faced with punitive damages for their line of work. And lastly, I would like to also add that it was very fortunate that President Moon, despite his initial, problematic attitudes, in the end, as a former human rights lawyer, he did care about this kind of international criticism and also his historical legacy. So I think that's how we were able to have a happy ending. Thank you very much.
Thank you. Dr. Shin, I'd like to ask you to take a seat on the stage. I'm sorry, I'm not following instructions. We should be, we should be on the stage. International solidarity can be a very powerful form of pressure depending on the circumstances and on the environment. At this point, I think Melawi needs to make an announcement.
Melati, Mr. Joneri. My name is Melati Dewi.
Melati,
Yes.
I'm sorry.
Ladies and gentlemen, I just would like to give a short highlight. We are provide you with SIS equipment or simultaneous interpretation systems. For the interpretation, please kali select channel 8. Bapak Ibu sekalian, kami menyediakan alat penerjemahan untuk Bapak dan Ibu yang membutuhkan translasi atau interpretasi bisa memilih channel 8 untuk mendengarkan penerjemahan ke dalam bahasa Indonesia. Terima kasih. Thank you very much. Joneri, please kali proceed.
Thank you. Our next presenter won't be able to join us here, but Kulatsyada Chaipipat will present the experience of the COFACT participative fact-checking NGO in Thailand.
Good morning from Bangkok. My name is Kulatsyada Chaipipat. I am a media consultant and advisor to COFACT Thailand. I'm very pleased to be invited and represent COFACT Thailand at this meeting, and I thank the organizer, the World Justice Project, for inviting us to be part of this important discussion about principle, good practices, and challenges in combating disinformation in the context of Asia Pacific and Southeast Asia in particular. So let me begin by introducing COFACT. So we are a collaborative fact-checking network or crowdsourcing network founded in 2020 at the height of the pandemic, primarily to address disinformation issue in the context of pandemic and also concerning other health issue and alternative medicines and cure. However, we are already inspired by COFACT Taiwan, which seek to empower the citizens to be able to detect and defend themselves against disinformation. So our vision is we believe that everyone is a fact checker and we are against the state monopoly of truth. So our mission has three pillars: COFACT journalism, COFACT community, COFACT campaigns. In sum, we seek to promote non-legal approach to combating disinformation. In terms of the context in which we addressing disinformation, can be categorized in three main issues: state monopoly of truth, the state version of truth being used heavily to negate, to stifle criticism against the government. That has been very prevailing during the pandemic, in which the government used a fake news version to defend themselves against criticism and public scrutiny of their response to the COVID situation. Secondly, the state propaganda and information operation. This has been used over the past decade and more so in the past few years to boost government popularity and legitimacy, and at the expense of freedom of expression and freedom of speech. Thirdly, the state excessive use of security laws, electronic information laws, and defamation laws, and political machinery to stifle critics of the government and dissidents at the expense of democracy and social well-being. The challenge we face in addressing the disinformation issue, firstly, is the lack of consensus in the society to fight disinformation, partly due to the deep polarized political situation. Secondly, weakening democratic force, particularly the media. Not only the media practice self-censorship, it is also partisans. This prevents the media from providing constructive space for the public to discuss about pertinent issues that would help unlock the current political impasse. And this partly because of the authoritarian suppression and economic pressure that prevent the media from doing good journalism. Thirdly, the limited capacity, skills, and resources to fight disinformation. And how COFACT overcome this in the past few years. We are dynamic, flexible, and non-partisan kind of coalition. This is really helpful in building trust and at least and sustain broad-based support of the society, and despite the lack of consensus, as I mentioned at the beginning. In terms of impact, we grew from a few or a dozen of organizations and partners to more than 30 local and international partners. You can see from the screen. In terms of social media engagement, it's growing, although it's still limited. However, our website managed to interest quite a huge number of users. It's grew to like 500,000 users. Also in live chatbot, we have like over 7,000 followers. Our products of the past 2 year efforts, we produced multimedia content, special reports, article pertaining the trend in disinformation, efforts in combat disinformation, both local and international levels. And we organize a lot of public and digital forums, all combined to produce perhaps over 100 pieces of article. And our fact-check database grow into almost 6,000 pieces thus far. And in the light of the current political conundrum and toxic information ecosystem, we are well placed to provide impartial and inclusive civic space for fact-based, sensible and constructive dialogue, so as to provide alternative policy recommendation to the society. So lesson learned. Trust building and networking is a key to engage and expand interested fact-checking parties and partnership for information and digital literacy. The way forward. We believe that we need strategic approach and timely response to the issue. We sort of identify key areas of problem and pressing issue to address the concern of the public to increase impact and sustain the network. Here we have like 3 main focus in the coming years: health literacy, political disinformation, and cyber crimes. So that's it for COFAC and our work. So if you are interested to know more about our work, please email Supinya Granmalong, COFAC founder, or me, Gulashada, advisor to COFAC, or explore our platform, or to try Fact Collab at Line. Just scan Line or visit cofac.org. Thank you very much.
Thank you very much, Kulachada Chaipipat of COFACT Thailand. Your success stories inspiring many journalists and other members of civil society across Southeast Asia. Our third presenter is Ms. Haira Basit of the Digital Rights Foundation of Pakistan.
Hello, everyone. My name is Haira Basit. And as they introduced me, I'm here from Digital Rights Foundation in Pakistan. Can we have the slides up, please? So in 2001, the Federal Investigation Agency, the FIA, which investigates cybercrimes in Pakistan, received 102,000 cases of cybercrimes, complaints of cybercrimes. But out of these, about 1,200 cases were actually registered. So out of these 1,200, about 20% of the cases had an element of online violence against women or children. And in about 23% of them, Facebook was used as a medium to actually perpetrate the crime. Now, in 2016, since 2016, the numbers of complaints that have been brought forward to the FIA have exponentially grown. In 2021, like I just said, they have crossed into the 6-digit mark. In 2016, DRF, as you know, founded by Nigata, and we've been working on research and advocacy related to digital rights, privacy, and everything. So in 2016, we were working on the project Hamara Internet, which translates to Our Internet, where our trainers would go to schools, colleges, universities, and train young women to learn to protect themselves better online and fight online harassment. And inevitably, after each session, a group of girls would come up to the trainers and they would all say the same thing: we're being harassed online, we cannot tell our friends or family, and we don't know what to do about it. Can you please help us? And so after each session, the number of people who were reaching out to my colleagues at DRF, it grew so much that they felt that they had to expand towards a bigger project. Now, around that time, they also did a survey in which they learned that about 34% of the women had experienced some form of online harassment. These are young women in Pakistan. About 50% of them said that they knew a woman who had experienced online harassment. And about 70% of them said that they were afraid to put up their pictures online because they were afraid that it would be misused. So, next please. So in December 2016, Digital Rights Foundation started the Cyber Harassment Helpline in response to the number of complaints that we were getting, and because we saw that there was a gap in the crimes that were happening, in the experiences of the women, and the awareness that they had to go back and fight or protect themselves against this form of harassment. And also, of course, that they felt completely alone in this whole situation. Now, broadly speaking, the helpline provides 3 basic services, which is, and of course, we prioritize a confidential and non-judgmental space because that's the experience that we got from the young women. They didn't have a place that they could go to where they could feel comfortable in explaining what they were going through and not feel judged for it. So broadly speaking, we provide 3 kinds of services, which is legal support, digital security advice, and psychosocial and well-being support, which includes mental health counseling. Now, we also refer cases. Now, over the years, as the legal landscape has changed and our experience at the helpline has changed, we refer cases to relevant government agencies, so the FIA, but also gender protection programs, other law enforcement agencies such as the police. We also have escalation channels with various social media companies because, as I just said, most of these crimes are perpetrated over social media, Facebook, Instagram, Twitter, TikTok. So we have escalation channels with social media companies, and that also includes Google, YouTube. And we also have developed a referral system, a directory of sorts, where we can refer our complainants to trusted organizations where the complaint that they brought to us goes beyond our scope, the scope that, of help that we can provide to them. Next, please. So, so just a week ago, on 1st December 2022, we've completed 6 years at the helpline, and in that period, we've received more than 14,000 cases. We can move forward. This is just a picture of our helpline room and the Hamara Internet project. So we prioritize providing help to, of course, young women and girls, but also other gender minorities, including the transgender folks, non-binary people, and other sexual minorities. But we also see that the online harassment and violence that is faced in Pakistan makes certain vulnerable occupations especially prone to it. So our special focus is also on providing help to journalists, activists, human rights defenders, and lawyers. We can move forward. We provide help through 3 different mediums, which of course is the helpline, the phone, but also through help desk emails and through social medias, which also allows us to cater to people from outside of Pakistan. So yes, it's a nationwide helpline, but we also receive a lot of cases from Iran, Mexico, the US, Canada, countries in Europe. Forward. Again, and we don't like to say no to anyone, which makes us very knowledgeable in laws beyond cybercrimes as well. So as you can see, we receive a lot of cases in domestic violence, workplace harassment, physical harassment, generally gender-based violence all over beyond cyber crimes as well. Our legal department at DRF provides pro bono services to complainants who come from Lahore, which is the city where our office is based in. And forward. Over the years, we've seen that this number has stayed pretty steady. So about 68% of our complainants that reach out to us are women. About 30% of them are men. And we have a very small minority of gender minority or transgender folks especially. Move forward. So it's sort of difficult for us to gauge the exact, quantify the exact impact that we've had. Because we don't take personally identifiable information, which makes it, and we don't do follow-ups either. This is because, like I said, it's when women reach out to us, they don't feel like they can comfortably share their situation, their experience with their friends and family. And so when they call us, they're often doing it hiding from their friends and family. So we don't do follow-ups just to make sure that we don't put their safety at risk. But we did try to do a sort of a small questionnaire where the sample size was very small, but these are some of the questions that we want that we asked them, and questions like, did the digital help you received reduce the risk you were facing? And about more than 90% of them said yes. Our objective behind asking these questions was also to make sure whether our aims at the helpline were being met. So making sure that not only were they receiving short-term digital security support, but also ways to protect themselves in the long term. Were they more knowledgeable in the end? Were they able to not just protect themselves, but also their friends and family? Were they more comfortable in seeking legal help afterwards? So a lot of people don't feel comfortable in going to the FIA to report their cybercrimes because they feel, again, like their friends and family will find out, like they will be victimized, like they will be victim blamed for their actions, like because they mostly feel like they did something wrong, but just by being online. So we want to help them move forward from that thinking and realize that it's not a crime to be online or share your pictures or have social media profiles, but it's the perpetrators who are doing the crime, and that it's okay to go ahead and report this. We can move on to the next. These responses are mostly from journalists and activists and the gender and sexual minorities that we cater to. And so again, it's mostly, and we can see that the last question was, have you recommended the helpline to anyone? And about 70% or more of them have said yes. So we don't have the capacity to advertise our helpline, but so all of the cases that we receive are generally from word spreading about the helpline through word of mouth, friends telling friends, family members telling family members, but also through social media. So somebody happens to share our number on Instagram or WhatsApp group. Forward. Now I'm going to tell you a little about a case that we received that will help you get some idea of the kinds of cases that we receive and what we do in order to help those people out. So a woman came up to us recently. She called us at the helpline. She's about 45 years of age. She has young children in 3 or 4 kids in their early 20s. Now she was in a relationship with a man, and they'd taken some intimate pictures together, and they also the man had also taken some screenshots of the video chats that they had together. So after the relationship soured, the man started using those intimate pictures and screenshots to blackmail and defame her on WhatsApp groups, which had her entire family on it, and on Facebook. So she called us at the helpline, and because she was in a city a little far, about 2 or 3 hours away from Lahore, again where our office is based, we had to ask her to come to Lahore, to travel to Lahore, to register this. So problem number one, we have, anytime that you report a cybercrime to the FIA, you have to do so in person, because that's the fastest way to get the process moving forward. Eventually you have to report it in person anyway. So she had to travel 2 to 3 hours without any support. She's a housewife. She doesn't make any money. She had to bring one of her kids along with her for any kind of support. And eventually, because her family had found out, because the man's aim was to defame her in front of her family, she had to run away from her house. So because you have to report the cybercrimes in person, there are only 15 offices where you can do so in the whole of Pakistan. And so she had to travel 2 or 3 hours away from her home. That's problem one. And when she arrived in Lahore, we had to help her find shelter because there's no other place for women to go to. She also came from a lower socioeconomic background. Once she got here, we had to help her gather all the evidence, so take screenshots, make a whole packet, take it to the FIA, our legal team again, a brilliant group of young women went with her, registered, got the case registered, and eventually they had to face very small, minute issues. Like they found out where the perpetrator, the man, was, but he was also again about 4 to 5 hours away from Lahore. And they said that they didn't have money for patrol to go out and catch the guy. So then our legal team again had to write to the Director General of the FIA. They had a meeting with him, and they had to remind them of their responsibilities, after which the FIA officers that were assigned to the case, they received the money, got the patrol, and then went all the way to catch the guy. Another hiccup in the case was that when after the guy was caught, he was given bail just before Eid, which is one of the Muslim religious festivals, because the judge was feeling a little too generous, I guess. And so now he's out on a crime, and then he of course ran away, and now he's out. It's becoming more difficult to catch him, even after our legal team explained to them that him getting a bail would be very detrimental to the case. Well, now his bail is canceled, but they're again finding it very difficult to find out where he is. We can move forward, but this is, I'm just trying to explain what kind of problems the way we face with the FIA. It's not just the helpline that we offer. We also try to use the cases, once we attach ourselves to a case, we try to take it forward as much as we can. And then we try to identify the problems from the data that we've collected to go out and advocate for the work. So some of the things that we've done is also training of lawyers on digital rights, because we found that the legal landscape or the lawyers in our country weren't as well trained with how to interpret the act, with how to deal with the FIA and how to take those forward. Next, please. We've also done, so another problem that we face is a lack of gender sensitization with the FIA. So we've done trainings with the FIA to make them, make their first response not be victim blaming whenever someone comes forward. So I had another case where a young woman's intimate pictures were released on adult sites. And one of the officers, his first immediate response was, well, why did you take those pictures in the first place? Or we probably did something to deserve it. So we can try to conduct those trainings too. Next, please. We also collaborate with the Human Rights, the Ministry of Human Rights with their helpline. And next. And working consultations generally with the Punjab Commission on the status of women. Again, these are some of the interventions that we've done to try to sensitize people more towards the issues of the online violence that women face in our country, and what they can do more to, what steps they can take to make the whole situation better, so that women feel safe and more comfortable coming forward and reporting their crimes. Because it's only after reporting that these laws will be made better, that the whole processes will be made stronger. Next. Sorry. Yeah, I'm just finishing up. Next. So one of the, so I just like to wrap up by saying one or two points that we want to focus on moving forward is that recently at the IGF, someone rightly pointed out that we can't do a cross-border collaboration until nations, states, develop these cybercrime laws within their country. Mostly whenever people think of cybercrime laws, they tend to focus on financial crimes or stuff like that, and they tend to forget the gender-based aspect, the online violence aspect of it. So I just like to point out that it needs to focus on a time-sensitive, it is a time-sensitive matter, and that policies, whenever policies or laws are made focusing on online crime, online violence against women and children, they need to focus on how time-sensitive the matter is, that processes need to be done as quickly as possible, because once a picture out, it's very, for example, once a picture is out, it's very difficult to stop it from spreading, and that focus needs to be done on collecting the experiences of the people who are victimized primarily, and then learning from them what they want, how they would like the process to look like, and then building the laws and policies based on that. I'd also like to personally just because we receive a lot of cases from people in the U.S. Again from all over the world, and one of the main problems that we face is cross-border collaboration. We can work with the law enforcement within Pakistan, but it's very difficult to get other countries to follow along.
Thank you. Thank you very much, Hyra. Can I ask you to take a seat here? We're running a little long, but I want to take advantage of the presence of our two presenters. I'll tweak the schedule a bit. Let's have time for a couple of questions about the success stories that they presented to us. Questions from the floor, please. Yes.
Thank you. Hi, my name is Janjira from Thailand. I have a question for Evan. So I'm just wondering, I really appreciate you telling us the story and success experience of South Korea. But I'm just wondering, the fact that South Korea could gain kind of international traction when it comes to pushing back against this kind of law, does it have to do with the democratic nature of the country and the fact that the country is an advanced economy? And that is probably the reason why this combination of international and domestic pressure could work when it comes to pushing back against the law.
Thank you for the question. Yeah, so I think that's definitely true. And in fact, when I first made my appeal to the Special Rapporteur, I specifically mentioned that not only is this new law detrimental to the press freedom in South Korea, but that it can also be used by dictators around the world. They can actually cite the South Korean example to actually try to adopt similar legislation in their own countries. So I think that kind of I kind of consciously tried to make that kind of argument that this is not just confined to South Korea per se, but that it can also have this kind of international ramifications. And I told her that like I'm not really a big follower of K-pop, but I certainly don't want like this new kind of like fake news punitive damages law to be our next K-pop after the Parasite and the Squid Game. So that I think that kind of helped. And obviously, what this model is probably cannot be replicated in every situation, but I just wanted to show the potential in certain cases where the UN system can be used to uphold media freedom. Thank you.
Thank you. I think that's an even more shocking revelation. Dr. Chin is not into K-pop. Can I have another question, perhaps for Hyra?
It's not. It's working. Thank you very much. I'm Laude Sarif from Kemitraan. I just want to tell the audience that the Indonesian government just signed a new criminal code like a few days ago, and one of them actually criminalizing, for example, the publication of fake news. Fake news, according to whom, is not yet determined, but I think this will be another threat for the freedom of the people. But at the same time, also cyberbullying also actually happening here in Indonesia. So in fact, some of our grantees has been experiencing it, and we work with the Independent Journalists Association here in Indonesia. So this is not limited to Pakistan or the Philippines or Thailand, but I think this is a global phenomenon. So I propose if, for example, for Justice Project had to have some kind of like Asia Pacific coalition on safeguarding this new phenomenons or even a global alliance, I think it will be very important for us to keep us actually safe. We do have like a safe net here in Indonesia, but they are very small in organization. Then I would love actually to hear whether this kind of proposal can be actually, yeah, is it always better to work together than work alone? And I think because cyber is have no jurisdictional limitation, then I think we need also to work together. So I just want to hear the reaction from you all. Thank you very much.
Thank you. I think that's a great proposal. I think that's worthy of further consideration. Certainly, international solidarity has a real effect. I can speak from our experience in Rappler. Maria Ressa has a lot of international support, and that has served as a barrier. But there was another hand raised. Yes, yes, ma'am, please. Maybe we can have that as the last question.
Thank you. I'll just continue to Pak Laude's question. It's related. My name is Milda, and I have a question for Mila. Apologize if I...
Sorry, Hyra is in lieu of Mira.
Okay. As you mentioned that you have so many requests from other countries outside Pakistan, I was just wondering, how do you respond to those reports? As there are matters of jurisdiction and then different laws and regulations. How do you provide like a comfortness to them just to make sure that their reports is heard? Thank you.
Thank you for your question. So we don't necessarily need to provide legal help in every case that we receive. So from cases that we receive out of our jurisdiction, we can get away with just providing them, for example, if they want something removed off of their social media, so pictures removed, fake profiles removed, trying to defame them. Again, interventions that we can make in the digital sphere, those are something that we try to do. We've also, as I mentioned, the referral directory that we've developed has expanded beyond just Pakistan towards more other countries as well. So we try to see what organizations can help in that particular country and direct them towards those, especially for children.
All right, thank you. I'm sure there are other questions, but allow me to thank Dr. Ethan Hishok Chin and Hyra Basit. Thank you very much for your presentations. Now may I call on the next speakers. We've convened a terrific panel of experts. I'm going to call on all of them, and I'd like them to sit here. I will follow the instructions. Please sit here. We asked them to give opening remarks of 3 to 5 minutes. I'm hoping they will err on the side of the 3 minutes so that we'll have more time for the Q&A. It's 11:30. It's 10:30. Sorry, I'm still on Manila time. It's 10:33. We have about an hour left. So may I call on Dr. Shashi Jayakumar of Singapore, Dr. Janjira Sombat Unsiri, Aribowo Sasmito, and Jim Nolan. Thank you, and I apologize for mispronouncing the names. I can hardly read my own handwriting. Please. So we've all asked them to talk about the problem of disinformation and the impact on the rule of law. Maybe we can talk about that. So in that order, I'd like to ask them to speak. Hold on. Sashi, can you begin?
Thanks very much for the invitation. I'm honored to speak, and I feel a little bit under pressure. Just 3 to 5 minutes, I understand, to give the Singapore position on fake news, disinformation, and some thoughts going further. Well, I'll try, but I can't guarantee. My time has been spent mainly in government, but recently I've come out to think tanks where I'm a threat person. My think tank looks at threats, disinformation campaigns, hybrid warfare, these kinds of things. From the point of view of someone who's been in government looking at these kinds of issues, but also now in think tanks, the organized study of these sorts of issues begins very much roughly 2016 when the Trump election comes around. And you remember those days, Cambridge Analytica, allegations of Russian interference. So very soon after, Singapore government decides that this is an issue which needs to be looked at, and a very high-level parliamentary committee is convened to look at these issues. One of the key, and I testified, a number of my colleagues did as well. The select committee essentially decided that a hands-on-off approach is completely insufficient, and it doesn't really work. So alongside various non-legislative suggestions, there were suggestions and a recommendation that a law needed to be enacted to combat this issue of fake news. And that law, which is the Protection Against Online Falsehoods and Manipulations Act, became law in 2019. There are certain points about this law and indeed certain misconceptions, and within the 2.5 minutes I have left, I would like to clarify these. Under the law, innocently spreading false information is not an offense, but knowingly doing so is an offense. It is an offense to communicate a falsehood knowing or having reason to believe that this is against the public interest. These apply only to statements of fact. It does not apply to opinions and cannot be used just because the government happens to disagree with the statement. That's a key point. And in almost all the cases where the law has been used, the key limb is the correction direction. I don't have time to go into it, but essentially this is not forcing the other party to take down the falsehood. It's simply asking you to put up the government side of the story side by side, the corrective direction. So this has been useful, I think, from the government's point of view because it gives the government speed. You know the saying, the falsehood is halfway around the world before the truth gets its pants on. And it's been useful in particular to correct, amongst other things, COVID-related vaccine disinformation. But it rapidly becomes clear, even then, I think, that the main threat is not the innocent kind of misperceptions or innocent falsehoods, but foreign disinformation campaigns, subversion, basically. So the more recent bill, which parts of it, which was passed in October 2021, aims at preventing hostile information campaigns, HICs, which is the Foreign Interference and Countermeasures Act. And this gives the minister various powers. I do not have time, and I think it would be unfair to the other speakers to go into all of them. But the offense relate to clandestine, in the main, foreign interference by electronic communications activity, for example, on social media platforms. And this gives the minister powers to issue directions to various individuals and entities, such as the platforms themselves, other services, and to require information in order to help authorities investigate and counter hostile communications activities of foreign origin. Can I take one more minute? Look, I'm not here as a Singapore government spokesman. I'm not government, and I don't speak from a government perspective, and occasionally, I believe it or not, I disagree with government. So let me instead give you my personal as well as professional perspectives on where we are in Singapore and where we should be going. From my perspective, which is the threat lens, threat perception, which is what I work on professionally every day, subversion and FI, foreign interference, and hostile information campaigns will become the #1 priority, I think, for various nations in the region and indeed for the field. Disinformation and misinformation corrode the very structures of public trust. Individual falsehoods may evoke incredulity, but continued exposure breeds distrust. When people become confused and are no longer sure in terms of what to believe, or who conclude that the truth itself has been undermined, then democracies become very, very vulnerable. And this is much more pernicious than the other threat I spent time in government studying, which is terrorism. Terrorism, you can interdict groups, you can surveil them, you can keep them in check, you can try to de-radicalize people. But threats coming out of the gray zone, such as HICs, these are very, very difficult. Various key leaders have actually, in Singapore, given allusions to things which I think the intelligence services know a lot about, including actual facts relating to hostile disinformation campaigns, attempting to peel off, for example, one particular race in Singapore against the other, organized subversion. Of course, not all of this can be revealed in the public domain, but in public courts of law. But I see and work on these issues every day, and I see only about half, or maybe even less, of what government sees. So in conclusion, I would say that every nation state is addressing these. Every nation has to develop its tools. Singapore has its own model. I think Singapore doesn't preach. We make it a point not to do that. And of course, we can have a long debate on legal checks and safeguards. These things are important. And in fact, this is an issue with all national security measures, not just against HICs. How the balance is struck needs, in my view, to be developed and determined by the countries themselves. Thank you.
Thank you. A lot of very important points already on the table, and important new perspective on disinformation as foreign influence operations. Zanjira?
Thank you so much. Thank you, World Justice Forum and World Justice Project for inviting me here. What I'm about to share with you is drawn from my ongoing research project, which looks at laws, legal measures used to supposedly curb fake news, so-called fake news, disinformation in Asia. And I think I have 2 slides. If you can put that up, that would be great. I think I want to start off like this. I think the existence of online threats is real. We have heard about cyber bullies, harassment, hostile, posts that could create social incohesion, hate, so on and so forth. And so I think I want to, sort of demonstrate my awareness that these threats are real, they do exist. But what we are increasingly witnessing is the mismatch between the problems and a legal solution proposed by many governments. So many have talked about regulation, right? We need to regulate platforms, online space. And I think we have to be clear about the difference between regulations and criminalization. Yeah? And so what we have seen around the world is increased criminalization of those accused of spreading fake news or disinformation. Yeah? And what our project is interested in is to look into how these legal measures have been abused to stifle the opposition, dissidents, journalists, ordinary citizens who speak up against the authorities, and even the economic powers in their locality, right? And so, so far, and this is our rough counting. This is not even in a long span period of time, but we have counted 24 legal measures that have been implemented in South and Southeast Asia that are used to crack down on this misinformation. Next, please. And I think I don't want you to pay detailed attention into the laws, but because I'm amongst legal experts, I feel like as a political scientist, I have to show off a little bit, but please excuse me. I don't have any legal expertise, but what we are interested is how the legal becomes the political, right? And so I want you, as a political scientist, of course, when you see these laws being implemented, what we're interested in is regime type. And in South and Southeast Asia, there are a lot of autocratic characteristics, autocratic credentials of political regimes. And in Southeast Asia alone, if I am to count, Indonesia, as of 20, not even this year, as of 20, Indonesia is the only one standing electoral democracy in the region. And other than that, we have 5 electoral autocracies and 3 closed autocracies. And all of these regimes have imposed legal measures used to crack down on fake news. So here again, I have to highlight that we are not saying that we should not regulate online space and platforms, but criminalization of that is a different story. And so how our project looks into the process of criminalization, how that happens, how it works, right? And we demonstrate that there are two processes how this works. First of all, politicization. So what's interesting in these legal measures is the definition of what constitutes as fake news, misinformation, false information, distorted information. And this definition is definitely vague, very vague, usually vague. So the constitution of fake news is vague, but the consequences of fake news stipulated in these legal measures are clear. So the consequences of spreading fake news is usually associated with national insecurity, with terrorism, with all sorts of dangerous things. And so I just want to give you one example, very illustrative, and this is from the announcement in Cambodia on the publication controls of website and social media processing via the internet. Now, the announcement includes online harm that subject violators to legal punities. And these harms are defined as 1, national security, 2, public health, safety and finances, 3, diplomatic relations between Cambodia and other countries, 4, the outcome of a national election. So what this means is that if you challenge the Cambodian government in the aftermath of an election, you can be accused of spreading fake news. 5th, social cohesion. 6th, public confidence in the government and state institutions. Isn't that interesting? So if you basically criticize the government, the Cambodian government, you can be charged with spreading false news, right? And this is a pattern across our region and actually around the world. And so the politicization of definition is one process. The second process is weaponization of the legal measure. What this means is that once a critique of governments are defined or are alleged of spreading fake news or disinformation, then the critics would be charged. And this charge, and many of us here are aware of that, the charge is often piled up on top of other lawsuits, right? Many of the activists here have been charged with not only spreading disinformation, but defamation, sedition, terrorism, so on and so forth. So the weaponization of the laws and the anti-fake news laws, among other laws, is a pattern of lawfare, the use of law as a weapon against critique of the authority, right? And so the weaponization of the laws makes it difficult to protect freedom of expression, especially among civil societies. And so my last point is that you have to put the weaponization of anti-fake news laws in the ecosystem of disinformation. What I mean by this is that there's been an increased trend of state-backed cyber campaign to stigmatize dissidents, to demonize critique, and basically in Thailand, it's called information operations. In other countries, in the Philippines and in Indonesia, these are cyber troops. And so on the one hand, the authorities, governments manipulate online space in their favor. And usually this happens before the election, right? So the manipulation of online space happens, sponsored, backed, operated by state actors. And on the other, the laws to control the flow of information under the banner of curbing fake news is used against critique. So what you have is two sides of the same coin: information control ecosystem, manipulation campaign, and control campaigns through law. So that's what I would end here.
Thank you. Again, many important points backed by years of research. We'll have time to ask questions later. Now, let's hear from Jim of the International Federation of Journalists.
Hello, is that working? Yes. I must say, many of you will have seen the American movie Groundhog Day with Bill Murray. I must say I have a feeling that I'm participating in that every time I come to Indonesia and there's a new development in the law, such as the one that was introduced 2 days ago, because the problems that have been identified are not new. They're problems that have been with the legal system in Indonesia for many years. When I first came to Jakarta in 2004, when I was acting as a legal observer for the International Federation of Journalists at the now infamous Tempo trial of Bambang Harry Murty and the other Tempo journalists for criminal defamation of a crony of former President Suharto. They were convicted, and ultimately that conviction was set aside on appeal. But the same issues were there. This whole idea of coming to grips with what the illegal offence actually was in the face of extraordinary circumstances where, for example, Bambang Harry Murty was taken into taken into detention, and then he was unceremoniously assaulted by the bodyguard of the fellow who was the plaintiff in the defamation case. That's how bad it got. Anyway, that trial went on in dribs and drabs for about a year, but happily for us, it coincided with the 2004 election. So all the electoral candidates had to quickly reposition themselves and come out in favour of the journalists. But the problem was there were no legal to get rid of criminal defamation. Some years later, relatively few years later, there was a new law introduced called the Electronic Transactions Law, or the ITE law, and it made matters even worse because it made them more severe than criminal defamation. And of course, the IFJ and other journalists' organisations objected strenuously to this. There was a challenge taken to the Constitutional Court, which challenge unfortunately failed. But at the time, the minister was confronted about this proposal, this legal proposal, and he said quite shamelessly, "Oh, there's nothing, extraordinary about this proposal because after all it deals with is e-commerce, and after all, the Australians have got a law on e-commerce, this person's got a law on e-commerce, and that person's got a law on e-commerce." But at the time, we said, "Hang on a minute, look at the actual text of what you're proposing. This is a draconian, even more serious criminal defamation. It's just ridiculous." Oh, no. The law sailed through, and then several years later, and this coincided with the next national election, a woman, a housewife in suburban Jakarta, the outskirts of Jakarta, was suddenly picked up and put in jail because she put on her local blog comments that were critical of the local hospital. And suddenly, this ITE law was enlivened. She was put in jail, and the whole thing became a national scandal. And once again, the politicians all ran for cover and said, "Oh, this is terrible. This should never have happened. She's blameless." But of course, there was no decisive action taken to repeal that law or to fix it up. And so now we've got, as I say, Groundhog Day with this criminal case, because this repeats all of the problems that were inherent in the ITE law, the previous criminal defamation law. And so it's just more of the same, unfortunately. So that's the background against which we see this. But fortunately for Indonesia, there's been a very active journalist organisation and a lot of active civil society groups that campaign strenuously against these laws. And we can only hope that, once this one's been kicked down the road for 3 years, that by the time the next election comes around, if there's a new president, hopefully someone who will be the successor of Jokowi and be a bit more progressive, that something will be done about this criminal code. But we can't just sit on our laurels and hope that will happen. So Indonesia has at least still some prospect of a progressive future. And in the region, the only other country that's got a reasonable reputation for press freedom is Little Timor-Leste, where there have been a few interesting cases, but basically it's a beacon of press freedom in the region. The other countries have just gone from bad to worse, and we've heard mention of Cambodia, course, Myanmar is just appalling. And only recently at a regional conference of press councils, a representative of the Myanmar Press Council turned up, and he was just a propagandist for the Tatmadaw. And he gave this appalling speech saying how all the criticisms of the Tatmadaw were fake news, and we were just gobsmacked, and we attacked him, and he responded very bitterly, but he tried to ingratiate himself with the people at that conference, and he also raced around trying to get photographs taken of himself with Ramaphosa so he could go back to Myanmar and show what a great job he was doing and how he was well accepted internationally. Anyway, hopefully we put an end to that. But the problem in Myanmar has gone from bad to worse. Cambodia, has gone from bad to worse. If you're a journalist in any of these countries, you're in terrible trouble. You've really just got to get out or go underground. And that's been the fate of journalists, and so many, we could go into the statistics, so many people have been killed or jailed in both of those countries, but particularly more recently in Myanmar, because of their journalistic activities. So these are very, very serious and deep-seated problems that can't be readily sort of dealt with, and they can't be readily dealt with by easy changes in the law, because as we've seen time and time again, laws change, governments say that this is going to represent some sort of improvement in the state of things, but we find to our horror that it's actually gone backwards, and that's been the case in most of these jurisdictions. Rappler, of course, that's a notorious example. But about the Philippines, which also highlights these problems, is that the broadcasting regulation rules have been deprive important media outlets from the capacity to broadcast. There's a whole raft of legal measures that have been used against free expression and free media, and they're almost too many to count. But there's got to be pushback, and Indonesia is one place where you've got very active civil society groups, likewise, and there's no choice but for us to all push hard and try to mount international campaigns and international efforts to push back at these terrible events, and hopefully the changing government in Malaysia might have some impact on that as well regionally. We got excited last time there was a change of government in Malaysia, and we all trooped along with wish lists for things that needed to be done, and of course virtually nothing happened except that the fake law which we campaigned against was finally repealed, but it took a year for that to happen. So we can't get our hopes up too far in Malaysia's case, but certainly there's no let up as to the problems, and there's a real need for civil society organisations to work hard to promote the free press and to oppose these repressive laws. And of course, there's a role there for governments, not so much to get in officially, but to provide resources and support for civil society groups to undertake these sorts of campaigns. Because it might be awkward for governments to directly confront some of these characters, but it's not difficult for civil society groups to do that. In fact, it's their charter, and they should be encouraged to do so, and they should be resourced so that they can raise campaigns internationally. I could go on for hours about this topic, which you'll gather is one of my obsessions. In fact, it's probably my greatest obsession. But I'll be happy to answer any questions. But that may give you a bit of a flavour of what the feeling is about the position in the region.
Thank you, Jim, for bringing a historical perspective to the problem. Let me now call on Ari, who is one of the co-founders of Mafindo from Indonesia. I think he also has a PowerPoint presentation.
Thank you. Good morning, ladies and gentlemen. Really glad to be here, and specifically, I am happy that Mafindo is working with a lot of organizations on. Basically, we are cooperating and collaborating on not necessarily related to the rule of law. I've heard a lot about AIPJ's initiatives for the years. We also work with them, but the great news is that finally Mafindo gets invited to something that we are not directly related, because we're focusing on fact checking and digital literacy. But recent development showing that it turns out that Indonesia is one of the among top 10 countries, which eventually digital space will have to be governed because a lot of cybercrime, a lot of online scam, and it has been a tremendous amount of loss, a lot of victim, including the latest news would be the in one of large university in Indonesia, a lot of the student are we have how really easy to make online debt. Basically, you just need to hold your ID card and selfies, and then present it to the platform owners, and then you'll get certain amount of the money. And it turns out that a lot of victims already become the casualties. And I'm glad to thank you for the World Chess Day project for involving Mavindo in this, because eventually, although Mavindo is not directly working with law, then it looks like that sooner or later we're going to have to also jump in this program, because I think next year will be one of our partners who is asking Mavindo to working on the project related to the rule of law. And thank you for the slide. Next, please. This is several issues related to the uh, rule of law and what do you call it? Rule of law and regulation related to how you manage digital space, including social media. Previously, it was mentioned that social media already weaponized. This is something that I usually call it the conflict profiteering. Indonesia is also one of among the nations where we are divided online in social media. If you're familiar with the certain terms that both parties is calling each other using animal names, cebong and kampret. So since 2014, you'll see in day to day in social media, I call it the conflict profiteer, because polarization is being kept day to day in social media to make sure that both parties, since they are market anyway, there are certain person who's been using the conflict to gain for their own interest. So first one would be physically sovereign, but not in cyber or digital space, including in social media. Next. So basically, this is a problem that is not just limited to Indonesia only, but in most countries. I say, although nations are indeed sovereign, borders are physically at place, but digital space and social media are borderless. So next, please. The effect would be, at least this is my opinion, this has led the nation, they are not digitally sovereign. Their sovereignty is overtaken by social media as a global nation. It is true that in many countries, social media is a global platform. They have representative for the purpose of, for example, in Indonesia, for the easiness for government to contact them, and also for the purpose of tax. But a lot of time, the decisions still need to be discussed with their central office in US. Next, please. And second problem is that regulation is lag behind innovation. So whenever an innovation come up, the way how you regulate it using rule of law or other type of formal approach is difficult, because regulation is always behind innovation. For example, how do you regulate the ride-hailing companies? We have at the moment too. We have Gojek and we also have Grab. Are the transportation companies because they are operating a fleet of vehicles? The answer is no, because the way how they work is by, they call it partnership. They are working with drivers. They are working with drivers that own their own vehicles, either it is a car or bike. So if you call them an online companies, they'll be easily saying that no, we're not. Sorry, if you call them transportation companies, they will easily say that we're not transportation companies, your application companies. Now the problem is, if you call them application companies, they're not necessarily just an application company. So this is something that not just happened to only Indonesia, but back then I think either it's 2015 or 2016, even in Paris, conventional taxi drivers protesting the arrival of Uber, and they're actually burning tires. They are flipping vehicles. So this is something that happened to to many companies that the problem with regulation is that regulation is arguably always behind innovation. Next, please, the last part of the slide. Now, previously mentioned that rule of law regulation are often being misused for the ruling party to be oppressive, but at the same time, another problem is how do we find the balance between governing, ruling the digital space, which is a global nation, to find the balance between not being too free, because I'm not sure if there are such thing called true freedom. As we know, an attempt to regulate, to control social media and digital space are often considered as an attempt to limit the digital speech and expression. But at the same time, is there such thing called true freedom? What about if the freedom is also becomes the threat to the freedom itself? As you see, recently Elon Musk purchased Twitter, and we all see the way how he behaves in Twitter. Is it really is the kind of freedom that we all have? What about if the freedom is a threat to the freedom itself? So the biggest question, the biggest problem, global problem would be, how do you find the balance between governing, between creating rule of law to govern social media, but at the same time find the balance to ensure that it is not being misused for politically oppressing the other parties, the Indonesia at least, there are ruling parties and also the opposition, to make sure that the ruling party is not using it to misusing it to oppressive to the opposition party, and also make sure the balance between the freedom to speech and expression. Thank you.
Thank you very much, Ari. These are actually reflections on first principles related to the digital space. We have a wealth of expertise on stage, and we have 23 minutes left. Let's make the most of the time that we have. I would like to suggest that we don't ask concert pieces, like one question to be answered by all. To get more questions on the table, let's direct each question to a specific resource person. Yes, ma'am, over there. Yes.
I'm Somsi from Thailand. No? Thank to all speakers about fake news and misinformation that you inject this morning. You make me concerned a little bit about the fake news during the election. I have been experienced about the election observation for 15 years from my former, previous career in Asia. And I found that during these few years, both ruling party and opposition party use the information operation to attack each other and give wrong information to the people a lot. Recently, from my information that I got from Philippines, maybe John can share a little bit about the campaign. During the campaign of your election, you use a lot of information operation or I/O. In Thailand, we call I/O a lot. No? It's not new for us, but it's a kind of effective tool to undermine or to bully, to attack the activist NGO and civil society a lot, and it's worked. But recently, we also know that both sides use the same thing, but who got the big budget is the ruling party or the army, the government side. The budget is my tax and our tax that we pay to them, no? But they used to attack us. I'm an activist, human rights activist, and also the observer. And I'm worried that because next year will be our election, no? and welcome you to observe our election too in Thailand. But whether people will get the right information during the campaign or not, I'm not sure about that. I'm really worried about this, and I don't want this to be a culture of election campaign in Asia or Southeast Asia. So that is just my observation
Thank
and
you.
comment. Thank you.
The comment raises the question about election information or influence operations involving elections. Anyone? Ari?
Thank you. That's very, the question is really, we usually call it during election as borrowing from the hospitality and the tourist industry. We usually call it the high season. High season is where, mostly misinformation are being used in social media, and everyone here, I think, agree that both of the ruling parties and the opposition parties are using the social media as a place where it is instant, it is global, and it is also free, because after all, you just need to pay for the internet connection. With that, of course, you need to also pay with the cyber troops. In Indonesia, it is really popular to be called as buzzers. A few years ago, there was a media that actually interviews these buzzers the response is saying that there's this they operate on a location, but like previously what I call the conflict profiteering. These people are professional. They are using social media to divide the country, but what people do not realize is that since these people are professional, they are not using their emotion, they're not using their feeling. They're actually doing it professionally. They're doing it for money. So there was a situation where they stay in a house, one room. They make a fake social media profile. They make social media websites. They make also make websites. They're playing it both sides. So basically, they are making fake account and websites that support the ruling party, but at the same time, they also make both accounts, fake accounts, and websites supporting the opposition. So what a lot of people don't realize, usually, they're using their emotion, but what they do not realize is that they are actually just a victim of these professional people. So learning from Philippines, we actually talk with Maria Reza. It is important for countries that is about to have an election to you guys just have to collaborate. In Indonesia, we are learning from Philippines, from Czech, I think, the platform. So basically, we have checkfakta.com, where the Association of Indonesian Journalists, Independent Journalists Indonesia, the AJ Indonesia, and also the Association of Online Media, we get together to form checkfakta.com, where also Mafindo is part of the organization that initiated. For 2024 election, we are planning to have this large collaboration between journalists, media, fact checkers, along with the platform. So basically, we're going to publish the whole world, saying that we are experienced with the election, and in the next 2024, the information ecosystem, we are the one who will be guarding it. So it is important to collaborate and cooperate, because for misinformation, it is really unlikely that single organization will be able to do it alone. So you have a year. So basically, in Philippines, Maria Reza told us that we only have 3 months, which is obviously really not enough. Although she consider it as it's not a failure project. This is a project that other countries will also be able to learn, that it is important during the high season, during the general election, that everyone collaborate to guarding the election.
So collaboration and preparation. Sanjira, you want to add something?
Yeah.
And then after this, we'll take another question.
Yeah, I think this is very important. As I said, I think when we look at the abuse of law, would stifle critique of the authorities, right? We have to look at the other side, right? So the manipulation of information. And I agree that the actors involved in this kind of campaign are from, right? From the government, from the opposition, from state agencies sometimes. But I think, as our colleague here pointed out, we have to look into resources of actors who do this, right? So those who can tap into larger amount of budget, human resources, the campaigns tend to be more effective. The information operation environment in Thailand comes from both the opposition and state agencies. But when you look at state agencies, it comprises not only the army, there are other state agencies involved. And recently, the Ministry of Public Health during the COVID lockdown, right? And then you have individual politicians from ruling party that can tap into resources. And then you have civic organizations in support of ruling parties, the government. And so the industry of trolls for hire is something to watch. You know, it's very difficult to regulate this industry because on the one hand, they sometimes operate in disguise of PR agencies. And PR agencies are very normal during electoral campaigns, right? But these days, I think, if I'm not mistaken, in the case of Indonesia and Philippines, PR campaigns are also a part of spinning messages, tarnishing reputation of your political opponent. And I think most of the time this is gray area. It's not about true or false information, but it's about creating bad reputation, if not demonizing the other side. And I think there are now studies about how this online organized systematization of online hate can lead to actual physical harassment of individuals targeted as the enemy of the state. And I think during the elections, we will see that more and more because election is the pretext for, you know, for you to get rid of your political opponent.
Next question, please. Yes, please.
My name is Jenvi Lutfiananta. I was the member research institute BRIN. Yeah, my office very close. Yeah, this is I think the hoax is the cultural habit in Indonesia. Like example, yeah, I will ask some my leader. He was college in UGM, but they didn't have the number identified university. Yeah, I think I agree in Mavindo ya. It's very the hoax the best the hoax must be in the rule of the government. This is the truth. I was the research in the brain since 18 years. Yeah, I was the company we have the do the financial for the research. Yeah, I think maybe we have developed the big data for anti hoax in the world. It's very important because you can imagine in the world the hoax is the power. Very dangerous. Thank you, sir. What do you think?
No, we do agree with you. And there's great danger from all the hoaxes. Maybe we can mix. Yes, Hannah Lim of.
Hi, thank you very much. My question is directed to Dr. Shashi, but it relates to Pak Aribo's comments. Thank you for pointing out the question of how effective our traditional conceptualization of jurisdiction is in tackling a lot of these transboundary issues relating to misinformation. And I think it's something that will become a lot more common with more issues in the future where the source of the issue it may be overseas or the impact of the issue may also be overseas. So my question for Dr. Shashi is that you mentioned that every nation state has to find its own solution in addressing these concerns, but have you in your work seen sort of international approaches or collaboration or sort of tools and mechanisms to address these concerns, and how effective would you say they are?
Should I take that question now? No country has addressed this in a completely 100% successful way. If you want to take laws, Singapore has POFMA, the fake news law, and the Foreign Interference and Countermeasures Act, FICA. There have been laws on the books in various other nations for some considerable amount of time which address some or part of this. Foreign Agents Registration Act in the US. Australia has got a transparency scheme for registration as well. France has got a set of fake news laws which relate more to the electoral campaigning period. Germany has got the Network Enforcement Act. The UK is thinking about its online harms bill as we speak. The issue with transboundary cooperation is that, and I think this has been hinted at already, everybody is doing some of this, just like cyber capability, which has been alluded to elsewhere. Some of the big actors, which we may consider friends or variously adversaries, depending on the state of diplomatic relations, are always trying to influence us, sometimes at or just below or at the threshold of legitimate diplomatic activity. At other times, it segues into espionage. At other times, it segues into subversion. We in Singapore have been a target of all these kinds of things. Of course, I can speak with more authority from the Singapore point of view. And when it comes to uncovering or sharing in a bilateral manner the nitty-gritty, the nuts and bolts of how a hostile information campaign, HIC, operates, quite often this is a matter of sensitive intelligence cooperation. I can tell you it does take place, but it takes place more or less behind the scenes. On the second, more visible level, you do have these conglomerates. There's the Grand Committee headed by a former UK MP who was looking at these things, where various nations and their agencies and their think tankers get together either on a track 1.5 or track 2 level to talk generally about what should be done against hoaxes, subversion, information campaigns. Some of these are more useful than others. I will share with you the Singapore point of view because I've been part of these from time to time. When I try to do the circuit to say, hey, I'm from Singapore, let's exchange news on how to combat organized subversion, they're polite about it, but quite often you get their eyes glazing over after a certain point of time when I try to explain the Singapore point of view, the legal mechanisms, because, and again, they don't say this outright. They're like, oh, you're from Singapore, you're from the East, right? You're all about control, totalitarianism, China, or something like that. You're too polite to say so, but that's clearly there. That's unfortunate because that's not what we're trying to do. Every country is doing something. Most countries have realized there is a threat from organized subversion. Finding the landing point is a sovereign matter to be decided by the legislature and the security agencies and the people of that particular country. Unfortunately, when the prism is turned to countries in Southeast Asia, at least for Singapore, there's the perception that it's all about control. And unfortunately, in the organized combating of some of these threats, what Singapore has been saying from the get-go, which is it's actually not just about the laws, it's about early interventions, critical thinking, hoax mapping, which Indonesians actually do very well, and we're trying to learn from them. That part tends to be forgotten. And I can tell you from the think tank point of view, we're constantly reminding Singapore agencies, it's not just about the laws either. There are other things which need to be looked at.
Thank you. Sorry.
I think that there's a good practice on this already. It doesn't come from state actors as such, but it's actually come from association of lawyers. And I know this because there's a recent report from colleagues in Latin America where a group of human rights lawyers get together trying to pressure corporates for further accountability. So I think what you have to do, on the one hand, you have governments taking responsibility for protecting their citizens, but on the others, I think more and more we have to pressure corporate platforms, tech giants, to do more to protect internet users, right? And I think the area of this is content moderation, and this group of lawyers basically propose that in order for platforms to operate across border, under a common regulatory framework, they have to apply for something like ISO license, right? So otherwise, they are subject to 170 frameworks of content moderation from nation states. So if platforms don't want to do that, why don't they apply for this kind of license? And this is a standardized platform, standardized framework for content moderation. That platform, I think, increasingly want to comply with that. They don't want to moderate content nationally because that's very, very complicated. So I think this is one of the best.
Thank you. I want to take more questions, but at the same time, I want to make sure that we hear from a very important voice. I understand that Damar Juniarto, the executive director of the Southeast Asia Freedom of Expression Network, is here. Hi. Damar, can I ask you maybe a couple of minutes to share your reflections on the remarks from our experts?
Hello everyone, my name is Damar. I'm executive director of TechNet. I think this is a good discussion and this is a good debate relating on regulating disinformation or hoax. In 2009, 2018, we do our research inspecting all the laws in Southeast Asia where the state wants to regulate the hoaxes. And then we found out that number one, I think hoax is everywhere and it creates problems. And when we talk about problems, it apparently it also can create online harms and also dangers to others. But in the same thing, regulating the hoax is having a bigger problem. What we saw in Southeast Asia countries, whenever the state want to regulate the hoax or disinformation or fake news, it create and it erode the freedom of expression and freedom of media. For instance, what happened in Indonesia when we have the rules or regulation regarding anti-hoax or anti-fake news. Whenever there is a news outlet saying or criticizing the one like a police institution, because there is a report in the July about the sexual violence that's being not doing improper by the police, and then this media called Project Multatuli wrote about these problems on their outlet, and then immediately the day after, the police stamped the media as spreading hoaxes, and then this kind of attitude and also action reflects that please be careful whenever you want to regulate the hoax, because if you're not doing in a proper way, like Jajira said, what is the definition, what is the limitation that we want to regulate, what kind of action that we want to punish the spreader of the hoaxes, then everyone thought that the news or the content that not appropriate or not giving them a positive images, then they say it's hoaxes. So so the of course the research in 2018 need to be revisit again, because now in Singapore we already have POFMA, and then in Indonesia hoaxes is no longer under the ITE law; it will be under the penal code. So we need to look again, and then ask these questions. And think this is questions still like we have to find the answer very careful. Should we regulate the hoax? And then is there any exception like countries? Uh, and I'm suggesting that should be there should be exception of countries where the state has a reputation not upholding freedom of expression and freedom of media. Probably they have to uh, not allow on regulating the hoax since they will misuse or in terms of quoting the from Janjira, they can weaponize this law to curb the freedom of expression.
Thank you, Damar. It's already 11:30, but if, with your indulgence, let's have one more question and let's direct it to Jim. Question from the floor, please. At the back there, yes.
My name is Matthias. I'm citizen Jakarta. I think, Jim, you are the observer for Undang-Undang ITE, right? So what is the future of Indonesia, whether those law will be reformed through this activist or journalist association? If you can mention the names of that associations that, because this Undang-Undang ITE is really criminalize the citizen. It goes to the grassroots instead just the big political things.
Thank you. Jim?
Well, I've got great faith in the journalists in Indonesia pushing back because we've seen that happen since Reformasi, where there was a leadership by the journalists to establish RG, to establish the journalist code of ethics as the foundation document for free expression and the free activity of journalists, and the campaign for the Press Council, and that was a very significant victory because the Press Council crowded out the space of the other contenders for the authoritarian intrusion into freedom of expression, and that's had a salutary effect. It's not perfect, but it's had a salutary effect because the Press Council, it seems to me, has acted as a bulwark against more odious tendencies, and you'll see that reflected where the ITE law and some of those laws have been used against non-press, non-media actors, and you've seen the potential for those laws to be used against the press, but the Press Council is very sensible, very strategically put itself between the complaints of the press and has been able to keep those things at bay. Of course, I mean, there are a number of famous examples, but you'll remember just before the first Jokowi election, the Jakarta Post published a cartoon. It had the ISIS flag on it, and somebody came out of the blue and said, "Oh, you can't do that. That's blasphemous because the ISIS flag has got a passage from the Quran on it." And the Jakarta Post was made the subject of a complaint. I mean, it was just bizarre and ridiculous. And what happened, as I recall it, was that the complaint just didn't get anywhere because the Press Council took it over and said, "Look, this is inappropriate. It shouldn't be dealt with under the criminal code. It should be dealt with as a complaint that the Press Council could deal with." And the whole thing kind of finally died a natural death. But that was a good example of the Press Council making strategic interventions to protect the freedom of the mainstream press. That might be much of a consolation for people who are outside the press, but it's pretty important because it establishes and cements the right of the press to conduct its activities without fear of too much interference. Now, there's been an uneasy sort of truce, I suppose, between the press and some of these no-go areas, but for practical purposes, for most political activity, that's had a very salutary effect. And the Press Council has been something that I know the International Federation of Journalists and other organisations Raji, etc., have commended people in the region, press council and try to establish the protections for the press activities. And that was done in Malaysia, of course, last time around. When we all, as I said, we all got excited about the change of government. And there was a proposal for a media council, and we said, yep, that looks good, trying to replicate what happened in Indonesia. That's a good start. And of course, that all just died as the government collapsed over there. But I think it's going to be revived, and I think it's a good thing because it might be perfect. But remember, as I say, is the perfect is the enemy of the good. And if something like that can be established, that's well and good. So I've got a lot of optimism about the progress in Indonesia and the future of Indonesia, notwithstanding the past couple of days ago. One hopes now that you've got 3 years to digest this and to get on the front foot, one hopes that the next government hopefully will be reasonably progressive. I don't know what the breeze has been blowing, but it seems to me that there are a few candidates who are likely to be quite good. Hopefully a lot of work can be done to see that these regressive laws are rolled back before they actually come into force. Anyway, that's my hope.
Thank you, Jim. With that vote of confidence, we can end our conversation. I would like to thank Ari, Jim, Janjira, and Sashi for an excellent panel. Thank you and good morning.
Thank you very much, John Neri from Rappler, Philippines. Panelists, please kindly return to your seat. I think they love the sofa a lot. I think so. All right, Dr. Shashi, Dr. Janjira, Paribawa Sasmito, Jim Nolan. I would like to ask for your keenness to kindly return to your seat. They're very comfortable, I think. Baik Bapak Ibu, kita akan menunggu para panelis untuk kembali ke kursinya masing-masing. A good laugh, ladies and gentlemen. Without further ado, I would like to call back and invite back my lovely Mrs. Elizabeth Anderson to present the concluding discussions on final reflection and next step, and also the closing remarks of the Asia Pacific Justice Forum. Mrs. Elizabeth, please kindly lead the sessions. Thank you. Give the warmest applause, ladies and gentlemen.
Thank you very much, and what a rich couple of days we have had together. Thank you so much for all of you being here with us. To conclude our deliberations these 2 days, we have a special message from an eminent rule of law thinker and actor, Professor Vitit Muntarbon, who is former special rapporteur for, or is currently, I guess, the special rapporteur for the situation of human rights in Cambodia, and previously the rapporteur on a number of different issues and topics, and leader in the UN system on human rights and rule of law topics, as well as emeritus professor at Chulalongkorn University in Thailand. So his statement here on the screen.
The closing statement, I'd like to invite you to reflect on this topic, please. Rule of law versus law of rules, law of rulers. The term rule of law has a resonant ring which sounds both familiar and distant. It seems familiar because it is employed frequently by lawyers to analyze the makings of a legal system. Yet, it is deemed distant because it sounds legalese, harboring both the thin version and the thick version of its intrinsic self. The thin version covers various legal safeguards for litigants and the accused, such as fair trial, accompanied by the advocacy of an independent judiciary. The thicker version demands more, namely adherence to human rights and democracy. Whatever the version, what is equally important as the middle version is that it needs an adjective in front of it, namely international rule of law, rather than national rule of law. The former offers an element of objectivity based on international law, while the latter might be a hidden version of a subjective national system that is steeped in constraints on rights and freedoms, a far cry from international standards. The latter might open the door to an overreach of national laws in a setting of over-legislation as the hinterland for non-democratic elements, alias the law of rules, the law of rulers as instruments of authoritarian control. The international trend, witnessed by the Global Rule of Law Index, regrettably indicates a decline of the rule of law internationally, undermined impliedly by the spread of the law of rules, the law of rulers. It coincides with the reduced civic and political space witnessed in many parts of Asia Pacific and elsewhere as a disquieting contraction of the democratic landscape. It is thus timely for key stakeholders, jurists and more, to coalesce more assertively to strengthen various entry points, to open up that space rather than to overlook the global warning of negative seepage inherent in the political climate change. There are at least three gateways of note, namely access to justice, judicial integrity, cum independence, and freedom of expression, balancing with reasonable limitations. With regard to access to justice, the challenge is to facilitate access by people to a variety of ways and means to claim their rights, effectively and cost-effectively, with a view to redress and accountability. While access to ordinary court system is important, that system is at times distant and out of reach for those who do not have the means and who do not have the power. Thus, other options, such as administrative courts, specialized courts, arbitration, mediation, and local dispute settlement mechanisms are emerging. The spread of national human rights institutions, such as national human rights commissions, also offers broad outreach to enable affected persons to resort to non-judicial alternatives. Interestingly, the COVID-19 pandemic has also pressed for a more accessible system via technology, such as online links, with the courts to clear the backlog of cases. A number of Asia-Pacific countries witnessed constructive developments on this front as a lesson learned during the pandemic. Yet, there is no room for complacency. There's also an inequitable online gap, aggravated by poverty and disparities, worsened by the pandemic, which needs to be tackled. The overflow of inmates in the prisons of various countries, especially pre-trial cases, is often a testament to the poor being affected more than the rich. Obviously, the former have less access to bail, which can help to divert them from the detention systems pending trial. The situation is compounded by the fact that a retributive approach towards drugs-related cases pushes many into detention rather than towards rehabilitation. Political shackles imply that those dissenting against the top layer, rulers, of the system are incarcerated all too readily by non-democratic regimes that seek to self-perpetuate. Since justice is in essence a matter of leveraging with the power spectrum, checks and balances vis-à-vis ruling elites are essential, and a strong civil society, media, community-based non-government organizations, and human rights defenders, including jurists, are all critical cogs in the wheels of justice in the face of the spools and spinners of political power. There's then the issue of integrity and independence of the judiciary. This has to be understood against the political backdrop interfacing with judges and the like. In non-democracies and semi-democracies, members of the judiciary are highly unlikely to be independent from the executive branch or to embody a genuine sense of integrity, since they are more often than not compliant or subservient to you-know-who. An example of that trend was seen recently in a developing country where a local court, obviously co-opted by the rulers, ordered the deputy leader of the main opposition party to pay not far from $1 million for defaming the ruling political party, which controls all the seats in the national parliament. The case is thus called strategic litigation against political participation, SLAP, S-L-A-P-P, SLAP, as a complement to the other well-known SLAP, S-L-A-P-P, used against human rights defenders, namely strategic litigation against public participation, the other SLAP. A major cause for concern should be the double SLAP phenomenon. Yet, advocacy and related action are still needed to press for a quality-based judiciary. Much can be done to improve their selection, education, and training on human rights and democracy. Good remuneration helps to incentivize their work. Monitoring of the judiciary is also important to ensure a sense of transparency. Where there is self-regulation, so that the judiciary vets itself, it has to ensure that it complies with international standards and is scrutinized against corruption and biased practices. A simple stipulation to prohibit them from sitting on the executive board of political parties may help to ensure that judges are independent and are seen to be independent. Nurturing empathy is key to enabling them to reach out mentally to victims and litigants, revolving the judiciary to different areas of the country and to enable them to witness firsthand how the other deprived half lives, helps to create more understanding for socio-economic and other conditions. Judicial education should involve visits to prisons and other detention locations to witness the real conditions beyond the courts. Gender sensibility also needs to be maximized in the capacity building of judges through practical, ground-related work and exemplars from the very beginnings of judicial training. Inclusion of persons of different ethnicities, with disabilities, with gender diversity, with pluralistic backgrounds is key to building a judiciary that is at one with the community. Openness to critical analysis from others is another test for judicial transparency, and this invites appraisal and reform of contempt of court provisions in several countries which shield the judiciary excessively from fair comment and fair play. With regard to freedom of expression, the Asia-Pacific region is confronted with a morass of laws, rules of a prohibitive and inhibitive kind, entrenching censorship and self-censorship, especially in the face of more authoritarian trends. Those trends overplay the claim of national security, fake news, misinformation, and disinformation to enact a vast panoply of laws and rules which fail to comply with international standards. The state thus claims to be the arbiter and rulers of the truth. A dangerous, subjective exercise of monopolization rather than pluralization of information sources and opinions. Over legislation thus sanctifies the survival of those who control the reins of power. The litany of laws invites vigilance. Computer crimes law, online falsehood law, anti-fake news law, electronic transaction law, telecom law, internet gateway law, cybersecurity law, emergency decree, martial law, and national security, internal security law, etc., etc. To these can be added the challenging provisions of the criminal code in some settings, such as on sedition, lèse-majesté, and criminal defamation. Fortunately, international human rights law guides what should be permissible as constraints on the right to freedom of expression, in particular via Articles 19 and 20 of the Covenant on Civil and Political Rights, a key human rights treaty. Although that freedom of expression and some other rights, such as on freedom of peaceful assembly and privacy, are not absolute, the limitations to be imposed on them must comply with the international three-part test. Namely, the authorities must prove that the limitation in question is not arbitrary and is consonant with the international rule of law, the principle of legality, that it is necessary to respond to the risk, principle of necessity, and that it is proportionate to the circumstances, principle of proportionality. In any case, the fact that non-democracies keep the lid on freedom of expression is a root cause of misinformation and disinformation, exemplified by its propagandistic tendency and discontented grumblings below. The preferred approach is to aim for an educated public with digital literacy to cross-check information as part of open critical analysis. The more convincing entry point is to engender the personal wisdom through liberal education to choose not to believe fake news rather than to comply with a diktat from the top as to what to believe and disbelieve. In essence, the real risk might be fake national security from the authorities rather than alleged fake news from members of the public. After all, international relations analysts tell us that the notion of security is based on three possible threats, namely actual threats, potential threats, and fictitious threats. Fictitious means fake. And what if it emanates from the rulers, the rules of the state itself, in terms of its insidious self-justification? Fortunately, the UN human rights system helps to expose many of the discrepancies on this front to pierce the veil of opacity. Aptly, this leads to the issue of hate speech, especially in today's social media and related platforms. Is it to be countered by more law? International guidance, as above, indicates that a law is needed against incitement to hatred, which may lead to discrimination or violence. Namely, X provokes Y to do something nasty to Z, a triangular relationship, rather than a law against hate, namely X tells Y that X hates Y, a bilateral relationship. This is inherent in Article 20 of the said covenant. Thus, other strategies can be explored against hate speech. Again, there is no substitute for an educated population which is also blessed with some empathy towards other people. To some extent, people also have to bear a degree of critique, unless the latter is tantamount to defamation. And all countries already have laws on defamation, although internationally the trend is to decriminalize that law and aim for only civil liability. Friends can offer counter-speech and cross-checking to help protect those who are targeted through hateful messages. There can also be contractual obligations with internet service providers and platforms not to use hate speech, such as homophobia. The latter is also covered by existing self-regulation of the internet industry itself, which can take down such content. Care is needed, however, in regard to that content moderation, so that it reflects international standards mentioned and avoid censorship. In today's business world, there are also the UN Guiding Principles on Business and Human Rights, which invite due diligence measures from the industry to ensure compliance with human rights, especially via human rights impact assessments and related mitigation measures to prevent, reduce, and remedy infringements. Added to that is the balancing act with the right to privacy, which today opens the door to notice and take down of comments in breach of the right to privacy, otherwise known as the right to be forgotten. The situation is all the more futuristic now because digitalization and artificial intelligence linked with algorithmic ubiquity are already among us. Therefore, there are emerging issues of transparency, accessibility, portability of data, explainability of AI and algorithms, and accountability, coupled with gender sensibility and victim sensitivity, which calls for our attention as friends of the rule of law in a momentously, rapidly changing world. Despite all the uncertainties and vagaries of existence, bridging now between the animate and sentient humans and the inanimate and non-sentient robots, AI, used increasingly by authoritarian elements, jurists and stakeholders who are friends of human rights, democracy, peace, and sustainable development are here to carry the torch of hope and reason in concert and substantively embodying the rule of law, the international rule of law for all, rather than to be debilitated by the law of rulers, the law of rules. It is ultimately a commitment to universal justice. Humbly, with a sense of consciousness and conscience in our shared partnership and transformative destiny. Thank you very much.
So an important and inspiring statement to conclude our deliberations these 2 days. Professor Vitit underscores that we are building not just a national rule of law, but international rule of law that is inflected by appreciation for and adherence to international human rights law, international standards. I would argue it's also an international rule of law that is strengthened and informed by partnership across nations. And I think that's very much what we have been doing these last 2 days, is building partnerships for the rule of law. So I want to thank you all for being a part of that effort. And I want to say some special thank yous to special partners of the World Justice Project who have joined with us in convening this event the last 2 days. And that's first and foremost the Australian government, the Australia, Indonesia Justice Partnership for Justice, and Kemitraan, and who have just been invaluable partners to the World Justice Project in convening this event, and the staff in particular of those organizations who've carried the laboring oar of this convening. If I could ask you all to stand and be recognized, we are so indebted and taken very good care of us. I want to recognize also other supporters and sponsors of this event, the Singapore Ministry of Law, the Hong Kong Bar Association, LexisNexis Rule of Law Foundation, and Jupiter, whose generosity have made this wonderful gathering possible. Also, the members of the World Justice Project Global Private Sector Rule of Law Partnership, whose support helps us undertake this work year-round. So thank you very much, all of you, for joining in this effort, for building partnership. It's been a very rich few days. I've got lots of notes and cards that I need to follow up with, conversations to continue with many of you. We've, I think, really validated the focus on our 3 themes as critical challenges to the rule of law in this region and globally: judicial independence, access to justice, and ensuring a healthy information ecosystem. We've underscored the importance of data and evidence to inform our efforts around these topics, the potential of technology as a solution, but also bringing challenges of which we need to be mindful. The critical role of courageous leadership. We've heard from so many up here about that. And finally, the importance of partnership and collaboration. So thank you all for being a part of that, and I look forward to continuing the conversation over lunch outside. I want to also extend, we have a very generous invitation to the Supreme Court for dinner this evening. Those of you who will be here are welcome to come. There will be a bus leaving from the lobby at 4 o'clock this afternoon, and that will be a wonderful capstone for our time together. Finally, I want to, I think most everybody in this room probably knows, but just in case you don't, recognize Srirak Klipat, who's WJP's Director for Asia. Stand up. We are very much committed to this agenda, not just for these 2 days, but to carry this work forward on these 3 themes for the coming years. And Srirak will be leading this effort, and I encourage all of you to be in touch with him and look for ways in which we can build and sustain this very productive partnership. Thank you.
Thank you very much, Mrs. Elizabeth Anderson. Distinguished ladies and gentlemen, I think we all agree that the conclusion of the 2nd day of Asia Pacific Justice Forum, building partnership for the rule of law, is finding solutions, working together. Give the greatest applause one more time. Thank you so much. Before we are closing the entire forum, I would like to inform again, announcement. Please kindly bear with me. The first announcements will be for those who are invited. Do not forget to attend the WJP special sessions, which is building the business community for the rule of the law, taking the first step. This will be held in the Jaya room on the same floor. So for those who are invited, you could attend the meeting at 2 p.m. today. Second announcement. The lunch will be provided, will be served at the Fiesta restaurant at the lobby floor for everyone, every delegation and participant. The third announcement. As Mrs. Elizabeth Anderson already shared from the stage, that will be a visit to the Supreme Court at 4 p.m. this afternoon. The bus is leaving at 4 p.m. So we would like to ask for those, again, who are invited to gather in the lobby 15 minutes before 4 p.m. today. And please kindly confirm your attendancy or participations on the registration test with the committee. The next announcement, do not forget to return the SIS receiver or the interpretation devices to the registration desk again. Ladies and gentlemen, in the behalf or the entire committee and also the entire board of the delegations, my name is Melati Dewi. Sign out. Thank you so much. Wassalamualaikum warahmatullahi wabarakatuh. And before we are proceeding to the lunch, I would like to invite everyone to join on stage. We're going to capture the moment and conduct group photos. Committee, please kindly assist all delegation and participant. Bapak Ibu, kita minta kesediaannya untuk bergabung ke depan. Kita akan melakukan foto bersama. Panitia, kami mohon bantuannya untuk memindahkan meja saja.